contrary to the express provisions, Your Honor, of the Universal Health Act that reserve funds should not be transferred back to the National Treasury.
You mean to tell us such portion of the PhilHealth fund balance determined from that 80% allocation from sin taxes without presenting any evidence?
Your Honor, the express provisions of the GAA, Your Honor, refers to reserve funds, Your Honor. And the express provisions also of the Universal Health Code refers to reserve funds. So we are of the opinion, Your Honor, we submit, Your Honor, that these contrary opinions, these contrary rights, Your Honor, is the actual case or constitutional case in question, Your Honor, that the provision is contrary to law, contrary to the Constitution, also that the transfer also of the fund authorizing the Department of Finance to transfer is likewise unconstitutional because only the Constitution only allows the President, the head of the legislature, the chief, and the constitutional bodies to transfer reserve funds from one department to the other, Your Honor.
Are you in effect invoking the ruling of the court in the case of Samar versus the OTC, wherein the court emphatically declared that the determinative test in raising a petition before the court is that it must raise a question of law?
Yes, Your Honor, part of it is a question of law and the actual case in controversy, Your Honor. In such case, the actual case in controversy, in this case, Your Honor, as stated, is the conflict of rights between the Constitution alleged by the executive and the legislature to transfer funds vis-a-vis the express provision of the Constitution limiting the transfer of funds to the certain individuals, and also of the express provisions of the law prohibiting such transfer of reserve funds back to the Treasury.
Do you consider this case before this court as one of transcendental or paramount importance?
Yes, Your Honor, we submit that in our pleadings, Your Honor, that it is of transcendental importance and that the transcendental importance have given due course by this honorable court in a number of cases. And the health and welfare of the people, Your Honor, the transcendental importance of the basic right to health has been actually passed upon by this court in the case of Imbong, Your Honor.
May I now ask you substantive questions? Petitioners in GR numbers 274, 778, and 276-233 argue that Section 1, Paragraph D of the 2024 General Appropriation Act and the Department of Finance Circular 003-2024 are unconstitutional for being violative of the constitutional right to health enshrined in two constitutional provisions. Article 2, Section 15, which states that the state shall protect and promote the right to health of the people and instill health consciousness among them. The second one is Article 13, Section 11, which provides that the state shall adopt an integrated and comprehensive approach to health, which shall endeavor to make essential goods, health, and other social services available to the people, to all the people at an affordable cost. In the landmark case of Embong versus Ochoa, year number 204819, promulgated on April 8, 2014, the Supreme Court categorically declared these as self-executing provisions, and there is no need for legislation to implement the same. Still and all, it bears noting that the so-called threat to the right to health is rooted in the actions of both Congress and the Department of Finance that appear to stymie or impede the timely implementation of the universal health care system. Does the characterization of the constitutional right to health as self-executing provision mean that Congress would no longer have discretion to determine how it should promote the same?
Your Honor, the express provisions of the Universal Health Care Law is very clear, Your Honor. The specific amounts to be given to the health care is basically outlined in the Universal Health Care Law, such as already mentioned, some taxes, PABCOR, PCSO. That is not for the Congress to decide, Your Honor. That